a general overview. There's all sorts of directions you can go, and when we talk with people, we want to make sure that we're doing something that's a good fit for you. So you need to have a background with, even if you don't talk to me, if you talk to another attorney, you want to have a good foundation and recognize that it's not one size fits all. There's different things that meet different people's needs. So, when you talk about estate planning, the big picture is that it's about decisions about yourself, your own care, and your finances while you're alive, but if you need help with those things. And then once you've died, what happens with all your stuff? So that's really what we're looking at. We're looking at during your life as well as after your death. The name of this presentation was Avoiding Pitfalls. So I am going to highlight a few pitfalls as a way of talking about what you should do. And one of those is waiting too long. So we do encounter families, particularly it might be a son or daughter coming in with their elderly parent saying, we haven't done any planning, now what do we do? Sometimes we can still help. In other circumstances, the options that we have are much more limited because they really did wait too long. They waited until they really didn't have capacity to make a decision, or if they just barely had capacity, it's really hard. It's really hard to make those choices sometimes when you get to a certain point cognitively. So we just give a little plug to say, think about these things now, well before you need them. It's kind of like buying life insurance where you're purchasing something you hope you don't need for a very long time. Okay, so there's rules that govern who has capacity to make a decision. You do need to understand what you have. Do you have a basic understanding of what you own and what we're trying to accomplish? What will happen with those things that you own in the decisions that you're making? So an attorney will run the person through those kinds of questions if it's gray at all as to whether the person understands. There's a lot of tools that we're going to talk about today. We're going to touch on most of these briefly today. So these are all different sorts of tools that are part of estate planning, anywhere from wills and trusts to different kinds of powers of attorney, death beneficiary designations, different forms of ownership. So we're going to touch on each of those. And we're going to start with some of the things that impact you while you're alive. And there's more than you might think when you're thinking about estate planning. Another pitfall that we're going to talk about is in regard to who you're choosing to help you make decisions. And it might be someone who's going to help you make a healthcare decision, someone who's going to help manage your finances while you're alive, and then really after your death in some respects. And one pitfall that we see is that you choose someone in your family, perhaps, or even a friend, who's the nicest, sweetest person. And we don't want people who are mean. I'm not suggesting that you choose the meanest person, but you do need someone willing to make tough choices, okay? And one of those is in the area of medical decision making. So I'll launch into that, but it can be medical decisions that are very hard to make when the time comes. And it can be financially. Sometimes we have to make tough calls financially for our loved ones and be willing to do things that other family members might be resistant to. They might have to say no to people who are praying. We see older adults be prayed on much more frequently than I would ever think would happen. And you need someone who will be tough, and especially if there's any concern in the family that there be someone who might be pushing for their own way in a way that's not in your best interest. And we have to be honest with ourselves sometimes. It's most of the time when I sit with a family, they say, oh, our family they're gonna all be easy. They're gonna all, this isn't gonna be hard, they're not gonna fight. Unfortunately, when your loved one is ill, when they're declining, when they pass away, emotions are very high, even people who you think siblings and others that you think would just get along great don't always. So you need to really think through who you're selecting to be your decision maker and the possibilities that could come. So, and I'll just reiterate, you can interject with any questions that you want to. Raise your hand if you want to interrupt me. It's more fun if other people are talking and not just me. So, with medical decision making, a frequent document that you'll see is a healthcare power of attorney. And there's a lot of names for the same thing. It's also called a patient advocate designation. It's also called an advance directive. Those are 3 names for the same thing. Sometimes a doctor's office or a hospital will provide you with one. They want to make sure that you have selected a decision maker in the event that you're not able to make your own medical choice. And so some doctor's offices even, they'll ask you every single time you come in if you have one. And you can use a document that they're providing you with, but what I would suggest is that you make sure that that's usable in other places as well, and not just for their office, for their hospital. You want to have one that you can use anywhere, so that if there is an emergency, you've already selected your agent or your patient advocate who's going to make decisions for you. They're only effective if you're totally incapacitated. Okay, so by signing it, you're not giving away any right to make your own medical choices while you're able to. It's upon your incapacity. The other thing that I recommend that you do along with that power of attorney or patient advocate designation is that you also consider signing a HIPAA waiver. And a HIPAA, as most of you probably know, allows the people that you name on it to see your medical records, talk to the doctor. It's effective now, though. It's not upon your incapacity. It's effective now. And I recommend that you consider at least signing that, and that you sign one that's usable anywhere, not just for a specific doctor's office. And the reason for that is if we're not doing well health-wise, we want loved ones to be able to talk to the doctor for us. We're not feeling good, get on the phone, get information, sit with us in the appointment, help think through medical decisions. Even though you're not totally incapacitated, you just want that help. So if there's someone or a group of someone's that you trust with that power, I would consider signing a HIPAA waiver as well, because it enables them to help you a bit more easily than the power of attorney.
How many people can be on a HIPAA?
There's no limit to how many people can be on a HIPAA. So I do see in families naming the spouse, all their adult kids. Some people are naming a sibling, a friend. It doesn't have to be a child, but I do see anywhere from 1 to 4 or 5 people on a HIPAA. And obviously you're choosing people that you trust, that you don't mind having that information. But the difference, the primary difference is that they're not able to make a decision for you with that document. They're just privy to the information, and they would be able to help you think through decisions, hopefully. The other things that you see up there, a DNR, a do not necessitate, and a living will. Those are both a little bit different than what we were just talking about. So a lot of people will say to me, yeah, I want a DNR. I know that's what I want. And you do need to recognize that a DNR is a very specific document. It's different than what you're signing when you sign a power of attorney. A power of attorney will have end-of-life decision-making power in it. So if you sign that, you're giving your agent the ability to, for example, end treatment in certain situations. And that power of attorney spells out what those situations are. A DNR is very specific to out-of-hospital situations where you may need to be resuscitated, and it says do not do it for any reason, no matter why I need to be resuscitated. So let's say you stop breathing and the ambulance comes. If you have signed a DNR, they will not do CPR. And it doesn't matter why, so that's a super specific document, and you actually do have to have your physician sign off on a DNR as well. And a living will is something that is accepted in some states. It's technically not accepted in Michigan. What that is another planning tool where you specify your wishes for different medical scenarios, and it's very detailed in terms of if I'm in this kind of medical situation, I want this. If I'm in this kind of situation, I want this. It's super detailed. Technically, Michigan law doesn't recognize those. Now you can fill one out if you want, and what it does is it serves as guidance to your family, to your decision makers about what you want. It's not something that the hospital is going to take and make decisions based on. Your agent can make decisions based on that. So that's just something to be aware of, because you hear people talk about living wills, and if you go online, you're going to see information about it, and that's because in some states that's common to see. Does anybody have questions about the medical piece before I move on to financial stuff? So the other kind of power of attorney that you probably hear about a lot is a general durable power of attorney. Those are generally financial in nature, and they can be effective now or when you're incapacitated, and you make that choice when we're preparing that document. And you're selecting people to help you manage finances and other general things, and it can have all sorts of powers in it. So it can be very specific to only allow them to do certain things for you, or be intentionally very broad and give them a lot of power. So they could access your bank accounts, they can pay bills, they can file tax returns, they can talk to Nolan about how you have your retirement account set up, they can make changes to it. They can do sometimes extraordinary things. They could set up trusts for you. They could change beneficiary designations if you have all of those powers in the document. So what you specify is exactly the power that they're going to have. And it depends on what your goal is with that document. So if it's just to handle very basic things for you, you can limit those powers. If you say, hey, I don't know what I'm going to need. I might need long-term care Medicaid. I might need a nursing home. I might need Medicaid to pay my bills. And you're looking ahead to a scenario like that, then you might want to give your agent really expansive powers so that they can actually move your assets around, create trusts, change beneficiaries. It's going to make it easier for them to do that kind of planning for you if they need to. The flip side is, again, you really have to trust who you're choosing, because you're putting a lot of power into their hands. So it's a personal decision about what you need, who you have in your life to choose as that agent. And then you're deciding, do I want to make this effective now, or do I want to be incapacitated? And everybody feels differently about that. There are a lot of people who say, I'll just make it effective now. I don't need them to do this for me now, but I might get to a point where I want their help. You know, I might say, I'm done going to the bank, and I want someone else to do that for me. You know, I trust them to pay my bills and so forth. And so you might just make it effective now. Or you might say, nope, I'm going to do this myself until the doctor says I am not able. And then the power of attorney would kick in and be effective. So it's, you know, it's up to each family. So the pitfall here is you choose the smartest person. Go ahead. You have a question?
If you become their financial power of attorney, or even a durable power of attorney for health care, does any of that make it so that person then has to cover when they run out of money in a nursing home?
So
or
if
maybe you're going to
yeah.
cover that later, but
So whoever becomes the agent under those documents is not personally liable for anything. So if the person runs, if I've signed a power of attorney and I've made my sister the agent for me, and she's helping me, and then I run out of money, I don't have any way to pay my bills, she's not personally responsible with her own funds to pay my bills. Now, when you accept a job like being the agent or being the trustee of a trust or being the executor in a will, those are called fiduciary responsibilities. You do have fiduciary duties that you take on. So those are things like not commingling the money, not self-dealing. So I'm not, you don't use the money for yourself. You have to use it for that person's best interest. Basically, you're not stealing from the person,
Right.
those sorts of things. Now, if you violate those, now you're in trouble. But if you're upholding your duties, you're not personally responsible in any way. So, does that answer your question?
Yeah.
Okay.
Thank you.
Yeah. When you're choosing, some people will choose the smartest person. They think, well, it has to be the person who has expertise in this area. I have to find somebody to name who is just a financial wizard, real, if you have someone in the family who fits that bill, certainly consider naming them. But know that even if it's a person who doesn't have tons of experience with finance or the law, they can seek out that professional advice, okay, and pay for it out of your funds. So they might need to talk to a CPA, they might need to talk to a financial advisor, they might need to talk to a lawyer, but they can pay for those services out of your funds. They don't have to pay for that personally. You need to choose someone who is willing to go find the correct advice, okay? And of course, though, if there's someone who has a track record of not handling these things well, they're not a good choice, right? But, the family member who's trustworthy, who's going to communicate with the other family members, who's going to have your best interest at mind, who will make the hard choices if they need to, and they will take advice. Well, they take advice from the professionals who are guiding them, right? So, those are things to consider when you're choosing these people to make decisions. So today we're going to talk about trusts and wills. We're going to do a little compare and contrast. I'm going to start with introducing trusts. This is an oversimplified chart that we'll talk a little bit about. Trusts are a mystery to some people that don't interact with them a lot. And you start with a trust, you start with a legal document that's a set of rules on how to hold and spend a pot of money. A trust is really a receptacle or a pot for your assets. And there's all different kinds of trusts. And the kind that we're going to talk specifically about today is typically called a living trust, a revocable living trust. For a married couple, it may be called a joint trust. And you're setting it up while you're alive and typically funding it, at least in part, while you're alive. And by funding, I mean moving assets into the name of that trust. So you're putting some of your assets into this pot while you're alive. And you have a set of rules in it for what's going to happen with those assets, both while you're alive and after you die. And so in that way, it's like what we're used to with a will, where it gives instructions on how this is to be handled after your death. Okay, and so the person who's setting this up, who's creating it, there's all different names, again, for the same thing. So you'll see different stuff depending on who you're interacting with, but it's the grantor, the settlor, the trustor. I've even seen the creator, which sounds a little funny, but it's all the same thing. You're setting up, you're deciding on the rules that are going into this thing, and you're the one initially funding it, okay? And then who controls it? So if I'm setting up my own trust while I'm alive and kicking, I'm going to be the trustee of that trust. I'm going to manage it and control it. And then I'm going to name a succession of people after me to control it when I either am able because I'm incapacitated or I've died, right? So you can have a succession of people, again, that you're selecting. So we're thoughtfully thinking about who am I choosing to be this trustee. And then who gets the benefit of the stuff that's in the trust? Well, while I'm alive, it's me, right? I'm the primary beneficiary of this trust while I'm alive, or my spouse, both of us. And then if I'm incapacitated and I'm a trustee managing it for me, well, I'm still benefiting from it then. The trustee is managing it for me. And then once I've died, my beneficiaries who I've named are the ones who get those assets. And so it might be my children, it might be other people, it might be charities, and the rules in that trust then dictate how it gets split up, at what time those beneficiaries get those assets. So there's a lot of flexibility in a trust to do things the way you want. Another pitfall is forgetting to fund this thing. while you're alive. Okay, so, and this happens sadly all the time. A trust is a lot of work to set up. It's a more expensive option, and you need to properly fund it during your lifetime to have it work the way you intend it to work. And so a lot of people will go to the effort of meeting with an attorney, making all these decisions, getting this big fat binder of all these documents that you probably paid a significant amount for, and then they stop and they don't put the assets into the trust, okay? And then when you pass, or if you become incapacitated and it's too late to move those things, now the trust doesn't work the way you planned on it working, okay? So when we talk about moving things in, for an example, with real estate, you, generally speaking, want your trust to own your real estate. And so you do that with a deed. While you're alive, you like if you own your home, you transfer ownership of your home into the name of the trust. And then technically, the trust owns that property. And one of the reasons that people like trusts is to skip probate. And we'll talk about a little bit more about probate and how important it is or not to skip probate. But if you want to skip probate, that house needs to be in that trust before you die. If it's not, we have to go through probate to get it into your trust, and that's what we're trying to skip, okay? You skip probate that way because when you die, you didn't own that asset. Your trust owned it, so there's nothing we're going to probate, okay? So it's important that you follow through if you go to the work of setting up a trust and really pay attention to each of your assets and how to properly transfer them. Yeah?
I have two questions on funding the trust. The first one is on real estate. What's the benefit of putting your home in a trust versus a ladybird trust or a labor deed? And then on bank accounts, I'm with the credit union, and they said I couldn't put the account in the name of the trust, but as I die, my trust is a beneficiary. So those two circumstances.
Yeah. So we can talk about ladybird deeds now. You'll see it on a future slide. So a trust is one tool for avoiding probate, okay? We are going to talk about probate. I don't know that it's imperative for every person to avoid probate, number one. So we'll talk about probate. But a trust is a tool to avoid probate, and so is a ladybird deed. What it is it's not a trust. It's a specific type of deed that people refer to as a ladybird deed. It is named after Lady Bird Johnson. I don't know why. I don't know that but it's also called a transfer on death deed. Okay. Essentially, what you see on that deed is like a death beneficiary designation, like you're used to with your retirement accounts. It says, I own this property while I'm alive. At my death, if I still own it, it goes to these people. And you list the people and their addresses on the deed. And by virtue of doing that, when you die, the transfer to them is automatic with no need to go through probate. Okay, so that is another tool to keep real estate out of probate. It does not keep other assets out of probate. It keeps real estate out of probate. Okay, and then there's other additional tools for different types of assets. So sometimes if your sole goal with a trust is skipping probate, you can do it with other tools other than a trust. Okay, if you have other reasons why you might want a trust, well, then we might lean toward a trust instead of a ladybird deed. Did you have a follow-up question?
So only real estate is not included in probate, like a vehicle. A vehicle would be, even though in a codicil it's specified who it goes to, it still has to go to probate.
Okay, so different assets are treated differently in terms of whether they would have to go through probate or not. Okay, so and this is if you do no additional planning. If we don't have a trust, we don't have a ladybird deed, we don't have any of this, okay? So what would go through probate is real estate, vehicles, personal items, traditional bank accounts that you don't have a beneficiary named on, and there are some other things as well, but those are the big things that we talk about, that if you don't do any other planning, those are going to go through probate, okay? If you pass away though, and we'll talk about this, if you have kept your house out of probate with a ladybird deed, your bank accounts are of a really low value, and I'll talk about what I mean by low, and you just have vehicles, and those are your other asset, okay, that could potentially go through probate. If you're passing less than $60,000 in total value of vehicles that you owned when you died, then you can do a transfer of the Secretary of State by your heirs going in and filling out a form and bringing the death certificate. They can do a transfer to your heirs. So as long as you want your heirs to get your vehicle and you're passing under 60,000 and we don't have any other assets going to probate, we can skip probate with a vehicle, okay? Other assets like life insurance, IRAs, 401ks, all of the things that you might be dealing with Cornerstone on, those things generally have death beneficiary forms that you're filling out, okay? So those assets pass according to the form and how you filled it out. So it's important that you're checking periodically on how you have filled out your forms, because those are a contract. They pass straight to whoever you named. So you can name a person, you can name a trust. There's a variety of other things in combination of those things. But that form controls. It doesn't matter what we say in your will or your trust necessarily. That contract controls that asset, and those things stay out of probate. As long as you don't list my estate on your death beneficiary form or leave it blank, those things stay out of probate. Okay, so when you're thinking, oh, is everything going to go through probate? Well, we can keep your retirement accounts and your life insurance out by properly filling out the death beneficiary form. Okay, so we will talk a little bit more about some of those topics just in a minute here. So, you know, most of us are familiar with wills, and most people need a will, okay? There are plenty of people who pass without a will, but, you know, what, at a minimum, that would control what happens to your assets when you pass away, if you haven't done anything else, if you haven't done a trust, if you haven't done anything. It says what happens with things that are included in your estate when you die. You're selecting what's called a personal representative. Okay, it used to be called executor. That's still the word a lot of people use. Technically now it's personal representative under state law, and that's what your will say, is personal representative. Even if you do a trust, you're still going to have a will with it. Okay, any attorney that prepares a living trust for you is also going to do a will, and they're called pour-over wills. And what those are is a safety net in case you do forget to fund that trust. If you forget to put assets into the trust, that will says, when I die, put my stuff in my trust. But you have to go through probate to do that. And you've done all this work with the trust in advance, hoping to skip probate. So we hope we don't need that will, okay? The other thing people use wills for is nominating guardians. Right? So if you have a minor child, you have a disabled adult child, we're putting those kind of nominations into a will. Yeah, go ahead.
If you had made a will like in the 90s, right now, you know, the kids would be now married and stuff like that. How do you retract that will? And then, like if you draft up a new one, you know, we don't want to read the Franklin thing where there's different
Yeah.
Like, do you have to contact the first firm you went to and then sign something to retract that will?
So if you have an old will and then you do a new will and you actually properly sign the new will, by virtue of doing that, you are revoking the old one, okay? Even if you don't do anything else with it, technically you have revoked that by signing the new one.
Because it's the date.
And it says at the top, I hereby revoke all prior wills. Every will says that, and it doesn't say that it should, okay? So, that by virtue of signing the new one, you're revoking the old one. What I do recommend, though, is that if you've got old stuff hanging around that you know is void now, you know it's no good, you either shred it or you exit out and mark void on it, okay, in big letters. And if other people have copies of that, the other attorney's office, family members you gave it to, you communicate with them and say, I've revoked that old one now. Here's a copy of my new one, you know, if you want to share it with that person. I say shred it, or if you just, some people just can't bring themselves to shred legal documents. If you can't do that, you mark on it void, okay, because it is confusing. When you have done different versions of stuff over the years, you've got stacks of things in your house, you know, file cabinets, you've got all this stuff. If something happens to you, you want your loved ones to know exactly what your most recent wishes were and to follow those and not get confused by old stuff hanging around, okay?
Don't you also have the ability to register a will someplace?
You can register a will with the probate court, okay? Almost nobody does that anymore. You pay to do that. And I have found that people who did that forgot they did that, and then we do a new one, and they don't tell the probate court. So I don't know that adding that layer helps very many people. But it is an option. It is an option out there that more people used to do that quite a ways back. But so how do I pick? You know, do I do the little bit more, the extra effort to do a trust with the pour-over will, or do I just do simple wills? And we started talking about that. Well, some of it comes down to what your assets are, right? And also, what are my overarching goals? Okay, so you really do have to think through what are my goals, what's going to happen with my estate when I pass away, and how simple is it, how complicated is it to achieve my goals. So with a will, we're going to talk a little bit more about probate in a minute, but if you just do a will and you haven't done additional planning, let's say you own a home, you have vehicles, you have bank accounts, those assets are going to go through probate when you pass away, okay? And if you're a married couple and you jointly own those assets and just one of you dies, no probate, okay? The spouse is still the owner. When you've both died, though, there will be a probate process. It is not the nightmare that people may have heard. In Michigan, it can be quite simple and it can be fairly inexpensive. So what happens is you file a flurry of paperwork with the probate court. They are forms. Some people feel comfortable filling them out themselves. Some people want an attorney to help them with that. And you pay a filing fee, which is $175 right now. And then you do an inventory of what the person owned when they passed. And it's not their retirement accounts and the life insurance and all of that. It's just the stuff that might go through probate. And you pay an inventory fee to the court based on the size of the estate. And the amount of the fee is on a sliding scale, but for a middle-class family that just owns one piece of real estate, it's typically under $1,000 as an inventory fee to the court, okay? They are less complicated. It's just, they're just much simpler. For that reason, they are less expensive to set up. And you control where you want your assets to go at your death, those assets. And for some people, that's adequate. You know, maybe we add a Lady Bird deed to take care of the real estate. There are downsides to Lady Bird deeds. Some of the downsides are that when you name the beneficiaries on that deed and you pass, they immediately become joint owners. Okay, so if it's one person that you're naming, easy peasy. If it's multiple people, they're immediately joint owners. There is no executor or personal representative steering that ship. Okay, they just own it together. And they have to decide what to do with it and be agreeable about that. Some families, they can work that out. Other families, that's not a good idea. Okay. But there are different tools, so we can combine different tools. Why might I want to do a trust? Some people want a trust, they need a trust to achieve their goals, okay? So you keep it private, okay? A will, if you have to go to probate, a will does become part of the public record, okay? If you register it with the probate court, it's part of the public record. So do most people care and want to go look up your will? Probably not, but it is there, they could, okay? If you've opened a probate estate and you've filed that will now with the court. A trust can be kept private. For some people, that's very important to them. They want it to be private. And if that's important to you, you should strongly consider doing the trust or otherwise skipping probate, okay? The downside is the expense. If for some people probate would be messy and expensive because let's say they own a lot of pieces of real estate or there's something unusual that we're going to have to deal with, you weigh that and determine is the expense now worth it because when I die it's going to be cheaper and easier, okay? You do have a little bit more flexibility with how you leave your assets in a trust than you do in a will, okay? A trust allows you to have all kinds of nuances. For example, if we're wanting to name a lot of charities to get different shares, we're wanting to have lots of contingency planning, and by that I mean, well, I'm leaving it to my kids, but if that child's died, I want it to go to these other people. If this child's died, I want it to go to this charity. If, there's lots of contingency kind of work in it. It gives you that flexibility because in a will we can do something similar, but we can't do that with death beneficiary designations. Okay, so if someone has let's say the bulk of your estate is actually in an IRA, those death beneficiary forms associated with the IRA they're not going to give you the flexibility to have 15 different beneficiaries, all with contingencies to different people and different charities and those sorts of options. You can't do that on that kind of form. So instead, what we would do, if that's your goal, is something more complex like that, we would say, let's do a trust and spell out all of those details in this trust. And when you fill out that form with the IRA, you make it payable on your death to the trust. So it all gets dumped over to the trust immediately at your death. We're not going through probate. It's going straight to the trust, and it's going to get distributed out according to the terms of the trust. Okay. So that's a reason why you would want a trust. Another reason would be if you have someone who you want to leave assets to who has special planning that we need to do for them. They have disabilities. They're a really young child that we want to hold this money in trust until they're much older. They have other special considerations where you want to utilize a trust to hold their share long term. That would be a reason. Another reason might be you have a blended family and we need to do some different kind of planning where maybe it's a yours, mine, and ours kind of situation, and we need to give some gifts to some of the kids immediately, and then they're going to wait to get the rest until both the parents have died. We want to preserve some for the spouse, but still make sure that the kids from the previous marriage feel taken care of and loved. And we're doing that kind of planning. You probably need a trust, okay? So we talk about all that stuff. You should be talking about that with your estate planner. What really are my goals, and what's the simplest way to still achieve my goal, okay? So that's what we're thinking about. And I say don't choose it out of fear. Don't be afraid of the horror stories that you've heard, okay? And another pitfall that we're going to get to is be careful about listening to too much advice from your neighbor or your friend, because everybody's situation is different, right? Okay, the one person's horror story is not necessarily what happens to everybody. So you just be mindful of that. So we already hit on a lot of this. Beneficiary designations are a way to transfer assets outside of a will or a trust. Okay, so with retirement accounts, with life insurance and other investments, you have the opportunity to name death beneficiaries. A lot of banks let you do that now. Okay, so what that would be is what they call a TOD, transfer on death, or POD, payable on death. And it's a form that you fill out with your bank or sometimes even with a credit union. And it's not available on every single account, but more and more as an option where you can name essentially a beneficiary to the bank account who receives those assets immediately at your death. And you skip probate that way as well. It's going to go straight to that person. There's not always a great way to do that kind of contingency planning in the event that person's died. And it does go straight to them. So some people like that. They like that as another tool to try to stay out of probate. What I suggest is that you are very confident that if that person receives those funds at your death, that they'll use it the way you are hoping they'll use it. Some people say, well, I'm going to leave this account to this one particular child when I die, and they know that they're supposed to use it for my funeral. They're supposed to use it to pay my final bills. And you are trusting them to do that, because when you leave it to them that way, it is theirs. It does not belong to the estate or anybody else. It's theirs to do with whatever they choose. So hopefully they are honoring your wishes. Hopefully they have not died or become incapacitated themselves. Okay? So you need to think through those things and decide, is it really the best plan to do a transfer on death like that? Or do I want to have it handled the traditional way through a will or a trust, so that there is someone responsible who has to pay my bills and has to share the difference with my other heirs, or they're in trouble, right? So, and you've got a succession of people named. In case one can't do it, you've got another person named, hopefully. So you do need to think through, practically speaking, what will happen when I'm gone with this money, and is it the best strategy or not? In some circumstances it is, especially if it's a relatively small amount of money.
So what happens if you did that transfer on death or payable on death account, and the person you named had passed away or wasn't there? What happens to that money then?
If there's no contingency, which a lot of times there isn't, you need one person or two people to get it 50-50, and there's no contingency. If there's not, then it passes to that person's heirs at law. Okay? And our state law, we'll get to this in a second, our state law says who your heirs are. Okay? So that's what would happen with it. Yep.
So if you say, like on your IRAs or your bank accounts, that you want the beneficiary to be your trust, is that when the bank will create the new account and name the trustee as the owner?
Yeah, so if you've named a living trust as a beneficiary, sometimes we already have a trust account. Let's say we already have a bank account that's titled in the name of the trust or the trustee for the trust. And because you might have done that yourself while you were alive, you may or may not have. If you haven't yet, and the trustee knows, well, there's money coming, there's money coming from the IRA, there's money coming from the sale of a house, the trustee then opens up a new bank account for the trust. You get a tax ID number for it. That trustee controls it. Okay? And it's at the point when you're ready to put money into it, whether it's you while you're alive or a trustee after you've died. Then we talked about ladybird deeds, and those are a nice tool. They work really well in some families. You need to think through whether it's going to work well in your family. I will say another nice thing about ladybird deeds is if you're thinking about, I might need long-term care, I might need nursing home, maybe I won't have enough money to pay for my nursing home, and I might need Medicaid. Okay, a ladybird deed is a nice tool in that kind of scenario. So generally speaking, when you go to apply for Medicaid, for for long-term care. Your home, if it's in your name, is an exempt asset. Okay, they don't, the state doesn't count that when they figure out whether you're financially eligible. But after you've died, if you've been utilizing the Medicaid for your care, the state does have a right to recoup the money that you've spent through Medicaid and get reimbursed through the value of your home. Okay, that's called Medicaid estate recovery. And a ladybird deed is a tool for avoiding estate recovery. If you keep it out of probate, we keep it out of estate recovery. Okay, so that can be a nice, some people like that. They think, well, if I spend all my other money on my care or other things, that's one asset that then I'm preserving for my heirs, and they would like that part of the plan. So that's something to consider that some people like. Okay. All right, let's see. I do want to touch on joint ownership. Let's see, ooh, I went too far. There. And let me see what time it is. Make sure I'm not taking too much of your time. So, some people really like the idea of making their kids or other people joint owners on everything while they're alive, or certain things. Okay, I'm gonna put my child on my house, I'm gonna put my child on my bank accounts, and maybe that's the way your mom or dad did it. That is the way that some people have chosen to handle their assets for a long time. They think, well, I trust this kid, they have my best interest at heart. Maybe they do. I mean, honestly, maybe they do. There are some things to consider when you do that. Again, kind of what we touched on. What if they die? What if something happens to them? Now it's not them that it's a joint owner, it's their heirs. You are, by doing that, you are expanding your risk. Okay, so technically, even though they might not feel like that money's theirs, they'll say, Mom, I know that's your money, that's not my money. Technically, if you've made them a joint owner, it is their money, it is their asset. If they get divorced, they get in a car wreck and they get sued, something of that nature happens, now you've put your assets at risk. You've increased your liability by adding a joint owner. Okay, so you need to think about that. And that's what I mean by there comes become your cubs. Okay. Giving away your stuff too soon. There are families who get super nervous about what if I spend all my money on my care? I want to give some of it away, or I want to be eligible for Medicaid, and so I'm going to give my stuff away. Be very careful about doing that. You might need it for yourself. Medicaid planning for long-term care is very complex calculations. You need to really think through, what am I giving away? How much is it worth? What is the timing of my gift? Okay, so be super careful about doing that. Okay. We talked about being careful who we're getting advice from, and it doesn't hurt to talk to friends and family, but do be careful. And we talked quite a bit about probate already, so I'm just gonna touch on some of this briefly. We go to probate, this is kind of the law that governs what happens when we pass away. We go to probate for guardianship and conservatorship, as well as dealing with estates and sometimes trusts. So the probate court is a court that is designed to protect vulnerable people and people's stuff. Okay, that's what the probate court is for. So it's not just this thing that happens when I die if I don't plan effectively. Sometimes we're going to the probate court because a person needs protection while they're alive, and that would be a guardianship or a conservatorship. And what a guardianship would be is a guardian appointed for you to make personal decisions for you, healthcare decisions, living arrangement, that kind of thing. Conservatorship is similar. A conservator would manage your resources for you, your assets and your income. It might be the same person, but they're two separate responsibilities. And you do have to go to court to establish these. Now, if you have signed really good powers of attorney, healthcare or general durable, hopefully both, you most likely will skip this piece. If you haven't named people ahead of time and you become incapacitated, you need a decision maker, then your loved one will have to go to court and be appointed as your guardian or conservator. So it's certainly helpful to
Tune into Cornerstone Retirement Partners' full radio program, Your Course to Retirement. Visit cornerstone-rp.com for many valuable resources, including those mentioned on this show and other great episodes of Your Course to Retirement.
The content of this radio show is provided for informational purposes only and is not a solicitation or recommendation of any investment strategy. You are encouraged to seek investment, tax, or legal advice from an independent professional advisor.
Ed Slott's Elite IRA Advisor Group is solely an indication that the financial advisor has attended training provided by Ed Slott and Company, passed biannual examinations on material covered at conferences and in webinars, and met other membership requirements, and does not constitute an endorsement of any kind. Ed Slott's Elite IRA Advisor Group members pay a fee for the educational programs that allow them to be included in the Ed Slott's Elite IRA Advisor Group. Membership does not guarantee investment success. Fiduciary duty extends solely to investment advisory advice and does not extend to other activities such as insurance or broker-dealer services.
Advisory services offered through Brookstone Capital Management, a registered investment advisor.
Advisory clients are charged a quarterly fee for assets under management, while insurance products pay a commission, which may result in a conflict of interest regarding compensation.
Any investments and/or investment strategies mentioned involve risk, including the possible loss of principal. Any comments regarding safe and secure investments and guaranteed income streams refer only to fixed insurance products. They do not refer in any way to securities or investment advisory products. Annuity guarantees are based solely on the financial strength and claims-paying ability of the issuing company. Withdrawals or growth from annuities may be taxable as ordinary income in the year it is taken. Individuals should review contracts for specific details of the product's features and costs. Early withdrawals may subject the owner to penalties, fees, or taxes.